I know that we kind of recommend stay away from an internal appeals committee. Definitely, obviously, have your internal committee. And wherever required, let either the complainant or the respondent use the statutory appeals mechanism. But I'd love to hear other voices on this also.
Hi everyone, good day and welcome to this episode of the POSHPod. We are discussing today the internal appeal mechanism under the POSH Act. Is the decision of an internal committee binding? Once the decision has been made, can we appeal it externally or do we first have to go through an internal appeal process? To discuss all of this, I have with me today Laxmi Char, co-founder Parity Consulting, an organization that works in the diversity and inclusion space. I am Bishen Jeswant, partner at Cyril Amarchand, and I work in the employment law practice and do a lot of work in the anti-sexual harassment space as well. So Lakshmi, let's get started.
All right. As always, Bishen, lots and lots of questions and too little time. But specific to the appeals process, and again, coming from the context of working with clients who have a list of questions around this, right? We know the POSH Act says the internal committee has to be set up. It tells us what the construct of that committee has to be. It also gives us a specific investigating process that the committee has to follow. And very interestingly, the final element that reverberates with us today is that the IC's recommendations need to be mandatorily implemented by the organization. In fact, there's even a time frame for that, right? When we're talking about appeals, the Act says, hey, here are the 1, 2, 3 appropriate authorities to which you can go and raise your appeal. And the U is either the complainant or the respondent, whoever wants to go on appeal. If we're talking about an internal appeals mechanism, is there something in the Act which guides the construct of the internal appeals mechanism? Like, do you have to have, for example, the head of HR in it, or, is there some recommendation?
Okay, so the language in the Act, let's be clear, is very bad. Okay, so the Act does not have any language about having an internal appeals mechanism.
Mm-hmm.
So it's not allowed or prohibited, neither. There is unfortunately some confusing, slightly ambiguous language in the Act about what the appeal process is. Section 18 of the Act talks about the appeal process, and it says, subject to your internal service rules, implying that you can have internal service rules about appeals. Subject to your internal service rules, the appeal will lie to a court or tribunal. In the absence of internal service rules, your appeal will lie to the authority under the Act, which is the authority under the Standing Orders Act.
Yes.
Right? Now, most other, I don't want to say no other legislation, but I think no other legislation, and definitely most other legislations, do not set out the appeal mechanism to be as per your service rules. The service rules of an employer will not guide what your statutory appeal process is. An employer's service rules can only talk about his own internal appeal mechanism. But over here, the Act says the service rules will guide whether you can go to a court or tribunal or whether you can go to a standing orders authority, right? So that's the first place where there is ambiguity under the Act. The language is simply not good enough, not clear enough, doesn't explain itself. But the fact that it says there is something in the service rules which can talk about appeals is what employers rely on to set out an internal appeal mechanism, right? Now, that internal appeal mechanism, what should it allow appeals for, again, is not set out, which means it is entirely at an employer's discretion as to what the appeal mechanism should be for. And the appeal mechanism can be for mainly a couple of things. You can either challenge the decision of the internal committee,
Sure.
right? Or you can challenge the process that the internal committee has undertaken to arrive at a decision. Both of these are possible. Now, while there is no right and wrong about what the process should be and what the ambit of the appeals mechanism should be, I would lean towards saying that the appeals mechanism should restrict itself to only dealing with the process issues around the IC. And the reason why I say that is what you alluded to, Lakshmi, earlier, because there is a process under the POSH Act. The internal committee is supposed to arrive at a finding. An employer is obliged to implement that decision of the internal committee. So then having another body sitting on top of the internal committee,
Exactly.
overruling the internal committee, is possibly something that a court will not look at as being a compliant measure. However, if that appeal committee on top of the internal committee is only reviewing the process that has been undertaken, and let's say that committee arrives at a finding that the individuals were not given a chance to be heard, not given a chance to adduce evidence, cross-examine witnesses, that there was a conflict of interest between the members of the IC and the parties involved, and therefore the process was wrong and has to be redone, for example. That is something which I can see a court upholding, because it is going towards ensuring that the internal committee process is correctly run, as opposed to overruling a correctly run process.
Okay.
And so that's where I'm coming from.
So if I look at it again in terms of operations, right, and we're saying, let's do a process audit. So this appellate authority, the internal appellate authority is actually, if I understand you correctly, an auditing mechanism for the process, whether the IC followed the process as laid down by the Act. So there's no, no organization, even if in its service rules, can magically make up a new process which is different from the POSH Act. They don't have the ability to do that. Now, the Act also says, Bishen, that the internal committee cannot take up complaints suo motu. So even if I'm on the committee and I am witness to something happening, I still cannot raise my hand and say, hey, I'm on the committee, that's, wrong, and therefore I will investigate it, right? I have to wait for the complaint to come to me. From a process auditing perspective, is it possible to set up, and again, I'm using operations terms over here, to say, hey, at random, 10% of all the complaints, we will audit the process, just exactly to your point, to give that comfort to the employees that, yes, we, the organization, are watching out for you. And we really do want to make sure that the process that's being followed as laid out by the POSH Act is as close to perfect as possible.
So the IC is meant to be an independent body.
Yes.
Right? The IC is not meant to be overseen by the employer.
Yes.
In this context, having another body supervising the IC at all times, not only when there is an issue, when some party is not happy with the decision, supervising the IC at all times is almost as if the employer is trying to involve themselves in the process and potentially influence the decision of the IC.
Correct.
That's how it can be viewed, to have a full-time supervising committee. So I would say that that's not something which is recommended, while not strictly prohibited. It's possible that it would be viewed as the IC not being unbiased, impartial, and entirely independent. So that's something I would not recommend. But just Laxmi, to go back to the point you made previously, when you indicated that it's a blanket no for an appeal committee to review the findings of an IC, I don't think it's a blanket no. I would say if the two options are either to review on merit or to review on process, and review on process is unlikely to be challenged successfully in court. Whereas review of the decision, I think there's a higher chance of it being challenged. The only reason I'm hesitating to say a blanket no, as in the appeal committee cannot review it, is because the Act doesn't prohibit it. It's just that such a committee is likely to be viewed as acting in contradiction of the provisions of the Act.
Yes.
The employer is likely to be viewed. I would not say it's 100% blanket no. That's the only point I wanted to make.
That's really interesting, because we're really going through it with a fine-tooth comb over here. There is the challenge at the end of the day that the Act says recommendations are mandatory. They cannot be adjusted or discounted in any way. We do see practically that there is a tendency within organizations that if there's somebody who is maybe a senior person in the organization, or even a very high performing employee, that there is a certain level of laxity which certain breaches are viewed by. So given all of that, at parity, I know that we kind of recommend stay away from an internal appeals committee. Definitely, obviously, have your internal committee. And wherever required, let either the complainant or the respondent use the statutory appeals mechanism. But I'd love to hear other voices on this also. So, hey viewers, it'll be great if you can write in what has been your experience. Have you been in an organization where an appeals committee is in place? If so, how well has it worked? What have you seen in your workplace? And Bishen, let's try and see if we can get some other voices as well.
Yeah, another voice on this episode is going to be Abe Abraham. Abe Abraham is a partner at Cyril Amarchand, works in the employment law practice, and does a lot of work in the anti-sexual harassment law space as well. So let's just log in and see what Abe has to say on this as well.
That'll be interesting.
Abe, thank you for joining us today.
Happy to be here, Bishen. Hi, Laxmi.
Hi there.
So Abe, what we're discussing today is around the statutory appeals process under the POSH Act and how the internal appeal mechanism that employers sometimes have ties in with the statutory process. So just wanted to hear from you what your experience has been. Have you found any issues in the implementation of internal appeal mechanisms? Does it contradict the statutory appeal process in any way? Just wanted to hear your thoughts on that.
Okay, maybe I'll just set out the background first so that it's clear to all that what we're getting into. There is a whole appeal process under the POSH Act. I call it POSH Act, the anti-sexual, the entire act, for short, we call it POSH Act. There is a mechanism, there's a section 18 read with the rule. That's very simple. What it says is that for any action, for any recommendations done that you're not happy about, you can, if you have service regulations, you can go to the court or to the tribunal. And by chance you don't have service regulations, then you have to go to the appellate authority under the Standing Orders Act. That's all. So basically the concept is that they identify the appellate body, which is a body outside of the organization. And the reason that obviously is because an appellate body has to be unbiased. And that's the reason they have created that system. What we have seen in my experience, I've seen that most of them, of course, talk about appellate bodies as per the law. What I've come across is on the internal appellate process that Bishen you spoke about, has come up, maybe not a widespread practice, but there is this concept of bringing in a system where you can keep the appeal process within the organization and nothing with a ulterior motive, mostly with the intent to keep and help the employees keep the entire system within the fold, such that they don't have to go to an outside body to look into to their issues that they have with the IC's recommendations. The problem that I've seen in my experience is basically threefold. One is that conceptually, there is no mistake of law. You can't take that excuse to say, I didn't know the law, so I didn't follow it. But here we're talking about anti-sexual harassment measures. So what happens is that I, as an employer, have a duty to explain to my employees what their rights and obligations are. Aggrieved women, male employees, everyone. I'm supposed to educate them. So as part of that, if I, in my policy, find a clause which says that the internal mechanism for appeal process is available, there is a risk that I see for employers that the employees might think that that is the only appeal process that is left. There is no appeal process outside of the system, which is an incorrect view, because even if you provide an internal system, they do have a right to go outside of the system because the law provides for it. So I think one caution that we all have to think about or we need to consider is that when we draft these policies, perhaps even if you want to have an internal process, identify that this is just an internal mechanism and every employee has the right to utilize the system that is there under law. So that's something that I think we all, when we draft, when we talk to the companies, that's something that they should just think about. Now that we've established that you can have perhaps an internal system, what are the other two issues that we should be all concerned about? Twofold. Basically, who's going to helmet? The IC body requires certain people from the organization. One, of course, is an unbiased member, which is fine, but others are all from the organization. Experience says that, though the law says get the IC members trained, help them, support them, we do all that. And now we have an internal appeal process. Who's going to help it? Because you already sometimes suffer the consequence of a poorly run IC. And if you don't have a properly, the person who can do a proper appeal hearing, that is just going to nullify everything that you're doing. So there is an effort then. The thing is, just not create system which you can't back it. You need to then put the effort to train the person also, such that the entire process looks and feels and is actually unbiased. So that's the second challenge I feel that an employer might face, because the appeal process that I'm talking about internal is always going to be held by somebody in the company. So you need to be very careful who that person is. It can't be just an identified body and then find out later there's a conflict of interest, because IC, of course, is unbiased. There's a whole system that you need to follow. But if the order comes through and the appeal body is somebody who is conflicted, it just doesn't make sense. So just be very careful of how you look into who needs to helm that process. That's one challenge that I think, I mean, very clearly we know that exists. And the other point is, what is this appeal for? Appeal, of course, is against a recommendation made, and a recommendation could be that the respondent goes scot-free. That's one. Second, it could be against or finding of guilt against the respondent. So, of course, the respondent also can go for appeal. Now, just think about it. You have an internal system where you're saying anybody can approach the internal appeal process and challenge the IC's recommendations. How practical is it going to be? Just thinking aloud, where a recommendation of a serious guilt has been established, and based on that, a termination order has been issued. I don't know how practical it's going to be for the appellate body for it to change that recommendation. It's going to be very difficult, because you need to be brave. So put it on record that I don't agree with this, then there is an issue really with the IC. That will just create more issues for the organization if anyone involved in the entire complaint mechanism goes outside and challenges it. So are you better off not doing so and allowing any of them who don't believe in the recommendation, just to allow them to do the right thing by going to the appeal process under the law, is a thought that I think we all need to, or the employers at least need to consider. These are the challenges that I've seen in this internal appeal process, Bishen.
Thanks, Abe. Abe, before you go though, if I can ask one follow-up question. See, you discussed in the last point about how it may be impractical and how the appeal body can really, reverse a decision on a serious guilt issue. I mean, where the guilt is determined and termination an order has been passed. Do you think though that it is illegal to have an internal appeal mechanism? Because the Act doesn't provide for it. Employer needs to take action based on the IC's finding. Now, can some other body change the IC's decision? Do you think there's an issue there?
Right. So I don't think it will be legal, so long as, the way I said, right, in my policy, if I made it very clear, it's a process that anybody who wants to voluntarily go for, happy to hear it. But I should be clear in my policy that they have an inherent right to approach the appellate body, who is the ultimate agency who looks into these things. So can I say that if that is right, I don't see illegality there. But what your point is, second point was, can the internal appeal process, and it can happen, and the question that I think you've raised is, let the internal process run through the entire proceedings and check it, and then decide that, sorry, I don't feel he's guilty. I don't see any value to it, because ultimately, if you don't implement the recommendation of the IC, so the IC has come out with a recommendation, found guilty and found recommendation. The internal body says, I don't agree, I cancel it out, I allow him to go scot-free. Net, the order has not been implemented. So if, for example, in this case, it will be the aggrieved woman who's going to challenge. She has every right to challenge it. And what she's going to do is, she's going to pick this up to say that the entire IC process also, even though the recommendation is in our favor, there is more to it than what has been caught by the IC. And therefore, the entire process should be brought before the judicial intervention or judicial scrutiny. That is not a good position at all. Is the actual issue with the way we may have the IC, but illegality, so long as I'm very clear, I'm giving you the option of going to the authorities, not taking it away. I don't think having an internal system is a problem. It's not illegal, but it's got ramifications on the organ.
So actually, Abe, I have a question as well, and not so much about the illegality, but more in terms of the optics. Because the Act is very clear. It says, constitute the IC. Here are the parameters for you to do it. This is the process you have to follow for the investigation. The recommendations are mandatory for the organization to implement. Now we're saying, if we have an internal appeal committee, what that then means is that typically and practically, that somebody perhaps who's designation-wise or in the hierarchy senior to the folk in the IC, those people are going to question the IC, right? So then where is the trust and confidence in the employee base? If another woman has a complaint that she would like to raise, is she going to think for herself that, hey, my friend raised the complaint, and even though the IC found in her favor, but the head of HR, and I'm making this up, the head of HR came in and said, nope, not happening. What's the point, right? So then, which then becomes a challenge for implementation of POSH as a whole.
As a whole, and a questioning of the IC itself, the fact that they exist and what exactly. So, Laxmi, the point here is, I think that's why we need to be very, we need to think carefully. The first reaction would be, don't need it. Let them go with the outside agency, because there is a statutory body, and the statutory body is not an internal. To be very clear, it's court, tribunal, or the appellate authority under the ISO. He's been appointed by law under the standing order. So you don't necessarily have to have it. The easiest answer to all this, take away all the issues, would be stick to the law, give them that possibility. And as I said, it's not a widespread phenomena that I'm seeing that everybody has it shoved into their policy saying have an internal policy. It's not happening that way, but illegal it may not be, but there are ramifications. So I think your point is very clear. You need to be extremely cautious about why do you need it? What is the purpose that you're solving? And once it is there, you can't wish it away, because then any person, even the angry woman, can try it. She can always come to it. But if it goes negative against her, I don't think then the organization is going to be well served with what it has ended up with.
Great. Thank you so much, Abe. Really appreciate your insights.
Thanks for joining this podcast, Abe. Thank you.
Thank you for having me here. Have a great day, everyone. Good day. Bye.
Thank you, Abe. Take care.
Bye-bye.
Bishen, that was really interesting what Abe had to say. What's your take on that?
So, I think there are a couple of factors to consider, to discuss here. One is that the POSH Act itself only protects women, right? And so any statutory appeal mechanisms which are available under the POSH Act will only be available to women. So if you don't have if an employer has gender neutral policies, and we are seeing a lot of companies today have gender neutral policies, and which means when there is a complaint by a man and the man cannot use the statutory appeal mechanism available under the Act, which then leaves him with no appeal mechanism. Which is a good reason to have an internal appeal mechanism. And when you have an internal appeal mechanism to deal with complaints involving men, where the man is the victim, you are not bound by all of the various restrictions that we just discussed, right? Even the IC technically is not required to follow the strict process that we just discussed. So some of these issues that we discussed about the decision of the IC being final and binding and the employer having to implement it, and a body sitting on top of the IC not being able to overrule that, does not apply. So we have a little bit more liberty with respect to having an appeal mechanism when the victim is a man. But at the same time, even for complaints involving women, where the complainant is a woman, there may still be a case to have an appeal mechanism. Because it does a couple of things. One, even for the woman, it's always an extra step, a more difficult step to go outside the organization and file an appeal. So having an avenue within the organization is a little bit, you could say, comforting from the employee's perspective as well. And even from the employer's perspective, like Abe indicated, it's not necessarily with an ulterior motive, but the employer has an opportunity to prevent a sensitive matter from becoming public, which is in the interest of the employees as well. It's one step before it goes to a statutory appeal. The internal appeal mechanism by no way prevents the matter from going to a statutory appeal subsequently. But if the matter can be addressed to the satisfaction of all parties involved, because only then will there not be an appeal, otherwise there will be an appeal by one of the two parties, then it's doing nobody any harm, but in fact benefits all parties. So there is a case to be made that an internal appeal mechanism does serve a purpose, but equally, like Abe said and like we discussed, there are restrictions around what that appeal mechanism can entail, and having them completely overrule the IC is only calling for trouble, because then the entire process that the IC is run gets called into question. It takes away confidence from the IC process, because employees now think the process can get easily overruled and things like that. So it's a bit of a balance, but I don't think there is a case to say no, there should be no internal appeals whatsoever.
Interesting. So we're looking at kind of like a risks and rewards, right, for each organization. and the philosophy with which they approach it. So if an organization, for example, as you said, has a gender neutral policy, then there are plenty more clauses and a lot more thinking that needs to go into it. It's not as simple as just saying that, hey, the POSH Act, we're just going to remove all the she pronouns or her pronouns and replace it with gender neutral pronouns, and then we're done. There's plenty more that needs to be thought through before it gets implemented. The final question I have in this in this space is, the IC has a 90-day deadline in terms of investigation and this thing. Should we also have, if an organization chooses to take the risk of having an internal appeals process, should they also think through a little bit in terms of timing and also in terms of who gets to sit in that appeals committee, right? Because if you've got the CEO and the head of HR and the head of engineering or whoever, we know already the optics are going to look bad.
No, definitely relevant, because if you want the internal appeals mechanism to be meaningful, it cannot be an appeal mechanism that runs past the statutory appeal timeline. So if I can file a statutory appeal in 90 days, my internal appeal mechanism must end before that.
Yeah.
It is pointless to have an appeal mechanism that runs in parallel with the statutory appeal mechanism, because one, nobody will then use it, because it essentially means that opting for the internal appeal mechanism means that you have to forego the external appeal mechanism, and that's not something which either of the parties will want, and neither is it something that in case of challenge a court will uphold. So the timeline definitely has to be kept in mind. And in terms of people on the committee, I would say the easiest way to ensure, well, you can't ensure, but increase your chances of the decision of the appeal committee not being struck down, is to run it in the same way as the IC would run the process.
Okay.
Right? To have a composition that's similar with 50% women, presiding officer being a woman, people who are competent and have an understanding about issues around women, sitting on that committee, and run the process in the same way in terms of giving the parties a chance to be heard, giving them a chance to present evidence, etc. Not necessarily on the merits, but even on the process. Whatever the ambit of that committee is, run it in a similar manner so that the chances of the decision of that committee being upheld are better.
Excellent. Thank you so much, Bishen, as always. Lovely to get so much of information. I hope that hasn't been information overload for you, audience. And do write in, do get in touch with us, like, subscribe, share the content that we're putting out, and let us know if there's something that you'd like for us to address or you think that we've missed out. Thank you.
Look forward to hearing from you. Bye-bye.